President.
The Leader of the Opposition.
Thank you, Mr President. I rise to lead for the opposition on the Electricity Supply Amendment Emergency Management Bill 2017. The opposition does not oppose the legislation, but we do have a query, which I will come to. The legislation streamlines emergency management powers in the event of an electricity supply emergency in the state, in part to take account of the privatisation of the electricity distribution system embarked upon by this government and this parliament, but also in part in relation to advice from the Chief Scientist and the government's Energy Security Taskforce, and in part also by the need from time to time to modernise the language in important legislation. In particular, the bill before the House amends Part 6 of the Energy and Utilities Administration Act 1987 to remove electricity from that emergency framework without disturbing its operation in relation to gas or to fuel emergencies. Instead, this legislation creates a new emergency framework specifically for electricity to be located in the electricity supply legislation. Under the scheme provided for by the bill, the Premier will be able to declare an electricity supply emergency by an order in writing if satisfied that the supply of electricity to all or any part of the state is significantly disrupted or there is a real risk that electricity supply may be significantly disrupted. At present, this power lies only with the Governor, pursuant to Section 24 of the Energy and Utilities Administration Act, and of course the Governor exercises the power only upon the advice of the elected government of the day. The bill replaces the current process of the Governor making emergency regulations with ministerial electricity supply emergency directions. At the moment, in Section 25 of the Energy and Utilities Administration Act, the Governor has regulatory powers to make regulations controlling, directing, restraining, prohibiting the sale, supply, use or consumption of forms of energy subject to the proclamation. And that does double up with the powers in Section 27, which provides for ministerial directions which are in existence at the present time. So this legislation, as it were, combines those two streams of authority. Interestingly, while the Governor's regulations were, I believe, disallowable instruments able to be superintended by this Parliament or by each House, the ministerial electricity supply emergency directions, both in the existing legislation and in the bill before this House, will not be subject to any disallowance or parliamentary oversight. That may be a matter that requires further thought in due course if necessary. While any declaration is in force, the Minister will be able to give directions reasonably necessary to respond to the emergency, including restricting electricity use and shutting down plant and equipment. In many senses, the powers of the Minister are expressed in more streamlined and limited terms than in the current legislation, I think, but certainly more clearly directed and clearer examples of the circumstances in which the Minister would make such directions appear to be encapsulated in the current bill. In a new development in the legislation, the Minister will also be able to require information to be provided in connection with an electricity supply emergency, whether there is a declared emergency or not, including for the purposes of determining whether the supply of electricity has been or is likely to be disrupted, and for preparing and planning responses to any future electricity supply emergency. In relation to this, Mr Assistant President, honourable members will recall recently the Springvale mine incident, and how could we forget, acknowledge that interjection, and of course the issue of the supply of coal to the Mount Piper power station. And there was a live controversy as to the amount of coal the power station in fact had at its disposal, and I note that this was a matter of some controversy in the Land and Environment Court proceedings, where evidence was going to be given about that matter. Of course, the parliamentary passage of legislation has rendered those proceedings moot, and I expect that evidence will not be given, at least in that forum. But in last week's first hearing of the select committee into electricity prices, which has been established by resolution of this House, evidence from the Australian Energy Market Operator did raise the issue about whether the national regulator had total and proper visibility of what was happening on the ground in relation to fuel supply and other important matters relating to energy security. So I'm assuming that this part of this bill is directed to those kinds of considerations, and we certainly have no objection to that. Finally, the legislation will empower authorised officers appointed by the Minister to enter premises and carry out investigations to determine whether a direction by the Minister has been complied with. This is perfectly reasonable and appropriate in the circumstances. As I indicated, electricity supply emergency directions can only be given while an order of the Premier is in force, although of course the information gathering powers will apply irrespective of a declaration being in place. A direction that applies to the general public or a section of the community is required to be published in the New South Wales Gazette. A direction that applies to a particular person can be given verbally if circumstances require this, and must be confirmed in writing as soon as practicable, and a copy of the notice must then be published in the New South Wales Gazette. Some examples of information that may be required include the location and availability of coal, gas and liquid fuel stocks and water storage reserves. An information notice does not depend on a Premier's declaration being in place, as I've indicated, and this is to assist the Energy Minister, whomever it may be from time to time, to obtain information for electricity emergency planning purposes. Appropriately, and I know the Minister made special mention of this in his second reading speech, the Minister's power to issue directions cannot be delegated under this legislation. It's appropriate that it be exercised personally by whoever the Minister is from time to time. The bill includes key offences for failure to comply with an electricity supply direction, failure to provide information required by the Minister, and obstruction of an authorised officer. I note the penalty levels in the bill are set at an equivalent level to existing maximum limits in the Electricity Supply Act 1995. However, Mr Assistant President, one of the provisions removed from application to electricity is Section 28 of the Energy and Utilities Administration Act, which enables a member of the New South Wales Industrial Relations Commission to be appointed to investigate any industrial matter to do with the extraction, production, provision, supply, transportation or distribution of any form of energy or energy resources in relation to which a declaration has been made. Those provisions, or that provision in the Energy and Utilities Administration Act, will remain in force and effect, as I understand it, in relation to gas and other and fuel issues, but will not apply to electricity and will not be transferred into this legislation. On this side of the House, we think it may be prudent to retain this tool for use by the state in appropriate circumstances in the legislation, and the opposition will propose an amendment to this effect. I do note that it would be applied or invoked in circumstances where the disruption to electricity supply arose from or had connection to or is in part related to an industrial dispute of some kind. And I invite honourable members to have a read of two adjournment speeches I gave in relation to difficulties being occasioned by the protracted bargaining between the Electrical Trades Union and Essential Energy over an expired enterprise agreement. There was something like 18 months of rolling stoppages in that industry because the parties could not agree on an appropriate new industrial instrument. And on two occasions I asked that the shareholder ministers involve themselves in the matter sensibly to bring the matter to a timely and appropriate conclusion. They didn't take up that suggestion, and ultimately the matter was resolved without that dispute impinging on the distribution and supply of electricity. But if it had gone on longer or occurred in different circumstances, it may well have done so. And so I think the Minister having this tool in the toolbox, if there is a dispute that touches on industrial matters or is driven by them, it's a device that the government of the day can use to diffuse that situation and carry into effect any recommendations made by the inquirer, if appropriate and necessary, to secure energy supply into the future. I think that this may have been an oversight in the drafting although it may not have been. In any case, we think it should be retained in the legislation. Certainly shouldn't be removed without a proper debate upon that subject, and so we would be urging the government and, of course, all other honourable members to embrace this sensible and balanced amendment that we will be proposing. The final point is that this is about emergency management. Emergencies, by definition, are sudden and, of course, hopefully of short duration. There is no limitation by time in the proclamation or declaration able to be given by the Premier of the day. And I think that probably is a mistake. I don't want the government of the day to be deprived of the tools it needs to deal with an emergency. But even if a declaration has to be renewed periodically in an extreme case, I do think that there should be some time limitation placed on the duration, even if then it does get rolled over or made again, because the restraint, even if it be only a formal one, created by the fact that it's a governor's proclamation of the advice of the Executive Council, is to be removed, and the decision is to be made by the administrative head of executive government. That restraint is not even there, and I think some time limitation in this circumstance would be warranted, even if, as long as a proclamation could be continued where necessary. And with those observations, Mr. Assistant President, as I indicated at the outset, we do not oppose the legislation.
Mr. Acting President.